a lot of time here, but I don't idolize constitutions. You shouldn't either. You should understand why it is we have them, look at them like a hard-nosed contract, and it should be just the way if you hire a roofing contractor and you read through this thing and you say, okay, I understand these terms, I'm going to sign here, and I'm going to pay you a little bit, but I'm not going to pay you the whole thing until you've done the job. And then both of you guys should be looking at this contract like a hawk. And if the roofing contractor comes back and he says, well, you know what, I need your money right now, and I'll do the job later, and you give him his money because you're an idiot, and he doesn't do the job, and he says, well, you know, it was a living document. No, nobody does this, right? This is much more important than a roofing contract, because even in Indiana, where maybe we don't have, we don't think about, I don't know, the governor doesn't send you to Iraq. Well, actually, if you read the Indiana Constitution, yes, he does, because we're not even supposed to have a standing federal army. The Dick Act of 1903 is totally unconstitutional. Let me get back on topic here. Let me just say, I'm going to hit some highlights of Article 1. And Article 1 in the Indiana Constitution is analogous to the Bill of Rights in the federal Constitution. Now, the federal Constitution had the Bill of Rights kind of tacked on. You had some people like George Mason or others who wouldn't sign the Constitution without those things in there. And they were really more or less to be clarifications. And I mean that, very specifically, because the Constitution is supposed to be the sole authorization of government. In fact, I want to read you what is arguably the most important sentence in the Indiana Constitution, and that is Article 1, Section 25. No law shall be passed, the taking effect of which shall be made to depend upon any authority except as provided in this Constitution. Do you guys understand what that means? It's a little bit of a difficult construction, but it's important to go over this. No law shall be passed that basically creates authority. All authority depends upon constitutions. So if the authority isn't granted in the Constitution, no law that the legislature writes, no judgment that a judge whips up out of his head, no executive action can create authority where it wasn't first granted in the Constitution. Do you guys understand what I'm talking about there? And the reason that is the most important concept is because I think this is the fundament, this is the basic foundation of the rule of law. And in the United States of America and in Indiana, the idea is supposed to be that these laws are the government of government. They are the police of the police. These laws are what decide whether it's appropriate for government to do something or not. And so when you guys were talking about sort of in abstract ways, the free market and whether, environmentally it makes sense to do this, well, actually there's a contract here. And if it ain't in here, if it isn't authorized by the contract, and let me just show you what we're talking about. This is the whole Indiana Constitution. This is printed out in 12-point type. This has got my comments in it, and as you might guess, I'm kind of a wordy guy. And so with my comments in this Constitution, and the whole Indiana Constitution, that's all the bigger it is. You can know these laws. You can read this, you can understand it, and then you can defend these laws if you choose to do that. Now, because they're, basically few enough to know, simple enough to understand, and important enough that everybody should understand them all the time, I think we need to get back to that Article 1, Section 5 statement again. Because we don't go anywhere until we understand this one point. And that if it ain't in the Constitution, it's not allowed. If it isn't specifically granted, it's absolutely denied. And that's one of those things that until we get that idea, we don't know what we're asking for with the rule of law. And I guess I'm not going to have any time to go over I've got a lot of highlights from the Article 1. I guess we'll have to get to these things later. But I think the key thing to keep in mind here is probably just that one concept, because I'm still seeing a little bit of stunned, silence kind of on people's eyes here when I say that all of the structures that we have, where we say court precedent, there is no constitutional thing as court precedent. Court precedent is not law. All legislative authority is supposed to be in the legislature. All executive authority is in the executive branch. And frankly, justices have very little authority at all. They can say words, but until the executive decides to execute that judgment, those words are just words. And all the words that really make a difference, the words that are law, are written down in constitutions, and that's both federal and state. Do I have time to take any questions at all? A minute? Does anybody have any questions? Yes?
Andrew, would you state how you can get a hold of a copy of the Indiana State Constitution?
Good question. I have my annotated copies, both federal and state, at wedeclare.wordpress.com. You can just download them as PDFs. And in fact, I think that my comments are fairly helpful because I think they highlight places where, if nothing else, it shows you where you really probably ought to just take a look and see if you agree with me or not, because they're way different from what we're doing right now. Way, way different. Any other question real quick?
Would you repeat that website?
We Declare, so it's just http://wedeclare.wordpress.com. And if you guys want, if anybody doesn't have access to the internet and you need a copy, just let me know and I will find some way to get you one because it's very, very important. Thanks.